You're handed a pen and told, sign on the dotted line. Should you? I'm Angelika Doebler, an attorney at Davis, Miles, McGuire, Gartner, and today we're going to talk about some common contract myths. First contract myth. If it's not in writing or it's not signed, it's not a valid contract. Probably false. Oral contracts are enforceable in Arizona. As long as the parties had an offer, an acceptance, and there was valid consideration, a court is going to hold the parties to the terms of their agreement. You see this a lot where oral contracts, especially for landscapers or somebody doing a renovation, a small renovation on a house, that you end up having an oral contract instead of actually written out. These are totally valid and enforceable. Of course, the problem is if you don't have a signed writing, it is more difficult to determine exactly what the terms of the contract were between the parties. And that's where you're going to really have to rely on your emails, your text messages, your invoices, things of that nature in order to show the court what the terms of your contract with the other party was. Now, there are some sorts of contracts in Arizona where the court will not enforce an oral contract. These are found under the Statute of Frauds, which can be found in Arizona Revised Statutes, Section 44-101. There's a whole list of them, but one of the common ones that I see is an oral contract for real estate. Arizona courts and legislature have held that contracts for real estate, there's just too much propensity for fraud for them to enforce oral contracts. And so therefore, you really need to make sure that any deal you have considering real estate is going to be in a signed writing. Now, even then, you're still not out of luck because there are exceptions to the statute of frauds even. So if there's part performance of that oral contract for real estate, such as that you paid substantial funds towards the purchase price and that the seller accepted those substantial funds, then it starts to show that maybe there actually is a valid contract between the parties. Of course, all of these are very fact specific and is going to really require a lot of legwork from your attorney in order to help you figure out the best way to put it and present it to the court. Second contract myth. We can figure it out later. Let's just sign now. I highly recommend you don't do that, but you probably didn't need me telling you that in order for you to really know that. You should check through your contracts to make sure that there is an integration or a merger clause. These integration or merger clauses say, this signed agreement is the complete agreement between the parties. So in one of these instances where there's maybe still terms of the deal to be worked out, and you say, no, let's just sign and get on with it. If that contract has that integration clause in it, then you're agreeing that there is nothing else to be discussed, that this is the full contract between the parties. So you have to be really careful to make sure that you're not saying that it's the complete contract between you when it actually isn't. Third contract myth. The parties are bound to the terms of the contract as they are written. Now, this is mostly true, but there are certain contract clauses that the court may find to be unenforceable as a matter of public policy. For instance, you can't contract with somebody to do something illegal. I can't go into a contract to say, oh, we're contracted because we're to rob a bank. The court's not going to find that to be an enforceable contract, even if it's written and the parties agreed to it. Other instances that I see are in employment contracts that contain onerous restrictive covenants or non-compete clauses. You may have signed an employment contract like this, where it says that once you terminate your employment relationship with the employer, that you may not be employed by a competitor of the business within a certain geographic area and within a certain time frame. Now, depending on those restrictions in the non-compete clause, the court may find them enforceable or maybe not. Arizona courts have found that very broad geographic regions, such as saying the entire state of Arizona, or really broad timeframes, such as you may not work for a competitor for the next 5 years, that these are too restrictive for employees and that that courts want individuals to be able to work where they choose to work. Now, your restrictive covenants may have more reasonable timeframes, such as you agree not to compete in 6 months from termination, or you agree not to be employed with a competitor within a 10-mile radius. Courts have generally found these sorts of restrictive covenants to be enforceable and have held parties to the contract as written. If you need help with your contract, please contact me at any time.